はい、それでは時間になりましたので、本日のセミナーを開催いたしたいと思います。本日は CCI コーポレートキャタリストインディアプライベートリミテッド並びに横浜インディアセンター様共催のセミナーにご参加いただきまして誠にありがとうございます。私は CCI の東京事務所でアドバイザーをしております河野和春と申します。本日の司会をさせていただきます。よろしくお願い申し上げます。CCI はインド全土に8拠点、700名余りの専門家によりまし会計監査法人でございますが、同時にビジネスコンサルトの業務も行っておりまして、数多くの日系企業様からもご愛顧をいただいております。ありがとうございます。本日のテーマでございますけれども、昨年の10月導入されましたインド新労働法に関してでございます。CCI の本社役員でございますヒマンシュ・スリバスターバ、同時にジャパンデスクの統括をしております、大変日本びいきの男でございますが、彼から話をいたします。スピーチは英語で行いますけれども、皆様がご覧になります画面の日本語資料は、その内容が彼のスピーチと連動しておりますので、そのようにご理解ください。開始の前に2つお願いがございます。1つは、皆様からのご質問ですが、画面にありますチャットボックスにご記入をいただきます。時間の許す限り、回答をしたいというふうに考えておりますが、毎日時間の都合でできない場合、後日メールにて回答をする予定でございます。もう一つ、横浜インドセンター様からのアンケートにご回答をお願いいたします。皆様のチャットボックスの中にアンケートのページに飛ぶ URL が記載されてございます。その URL を通じまして横浜インドセンター様のアンケートに回答ご協力をぜひよろしくお願い申し上げます。記入はこのセッションの間いつでも結構です。よろしくお願いいたします。それでは早速でございますけれども、本日のセミナーに移らせていただきます。Himanshuさん、it's your turn. Please go ahead.
皆さん、こんにちは。私はHimanshuです。私は弁護士兼会計士です。本日、発表できて光栄です。That was my very limited Japanese. But I would be now speaking in English because I'm going to be talking about a very important topic, and it's my favorite subject, the labor laws. And it's going to be impacting all companies, especially while I'm addressing all the Japanese companies today, because we are very much associated with the India-Japan corridor, thanks to my colleagues in Tokyo, like Kono-san, Maki-san, and our Japan desk. It is my duty to present a summary of this important piece of regulation, which has come recently. And since the impact is going to be in very immediate future, in fact, these laws are actually now effective, subject to notification of the rules, which I'm going to discuss in the slide. So it's one of the important landmark changes. As you know, India has a reputation of being very labor-centric, very difficult labor laws, but these amendments and these new labor codes are going to change such an impression and going to certainly add to the ease of doing business in India. So without much ado, I would now be presenting with you a summary of the key changes that I feel that all the audience members should be taking note of. Next. So this is the background of the Labor Codes 2020. As I just mentioned, that the existing labor legislations were very complex, archaic, and inconsistent with each other. So there was a lot of confusion in the implementation, in the monitoring, and in the administration. So which led to various kinds of issues. So in order to simplify the labor laws and to make the practice of labor laws much more simple, and to make India as a competitive location for foreign companies to do business, these reforms were proposed in 2019. So the first wage code that you see on the screen was actually implemented in year 2019, along with other three, which were referred to a committee for certain amendments. Unfortunately, due to the COVID impact, these were not implemented immediately, and now after a gap of nearly 1 year since the time the legislative machinery started working, the required changes were done and they were implemented. So they were passed as late as 3 months ago, and they're going to have the implementation effective next financial year. Next. So in order to present to you what has changed, so you would notice that there were almost nearly 40 labor laws, out of which all these laws have been summarized and concise in 4 codes: Wage Code, Occupational Safety and Health Code, Industrial Relation Code, and Social Security Code. So Wage Code comprises of 4 previous labor laws. Occupational Safety Health, or we call it OSH, comprises of 13 labor laws. Industrial Relation combines 3 major laws which were applicable on the industrial relationships. And Social Security law combines 9 labor laws. So this is going to simplify a lot of things, because the major advantage of these labor codes is that since they are implemented simultaneously, not much gap has been created between them. As I've already explained, they are consistent with each other. In previous labor laws, the major issue was that these laws were inconsistent with each other. That is, one law was talking a different definition and the other law had a different definition. But now all the consistency measures have been implemented, and because they are implemented together, there are minimal inconsistency, and of course there are certain typos which will get rectified in near future, but this is going to be a very effective mechanism. Once we understand these measures, it is easier for all the general affairs department and all HR departments, including the board of directors, to clearly understand the do's and don'ts, and they can prepare strategies around the workforce, for make policies for the workers, and implement the required changes, be it expansion of the company or closure or retrenchment of workforce. Now there are clear codes, clear guidelines as to what is to be done, how long it is going to take for approval, for what reason it can be rejected, and what is the remedy. So these labor codes are now going to make life much more simpler for all the HR professionals. Next slide, please. So even though wage code was implemented in 2019, I just wanted to update you that these were the 4 laws which were there earlier, and as you can see, these laws were very old. 1936 for Payment of Wages Act, 1948, 1965 for Payment of Bonus Act, and Equal Remuneration Act was a year 1976. So now they have been consolidated in 2019 together, and now the position of the legislation is very reform. These were the key features of the Wage Code 2019 that the government has now trying to fix a floor wage which is applicable pan-India. Some of the Japanese companies who are operating in India will understand that it is very difficult to consolidate and to effectively make one policy for the entire country because there are many states. So, and every state was defining their own rules and regulations, so it became very difficult. In fact, that is the hardship while Japanese corporate faced while working in India. Now, the government is trying to fix a uniform floor wage across the country. Of course, it can be still customized to the geographical needs, but it's going to be remaining a uniform wage rate. There is going to be a minimum wage which has to be paid to all the workers, so there cannot be any disparities between the wages of different workers, and these minimum wages will be notified by the central government, and of course state governments can keep a higher threshold for the workers working in the state. It is now also clarified that the overtime has to be paid in a ratio of twice the normal rate, which was not very consistent in earlier regulation. Another important change which has happened is in the case of deduction, that now it is not possible to deduct more than 50% of employees' wage on account of accommodation, fines, or recovery of any advances. So HR department now have to devise ways to to recover if there is a damage, how they recover it from the staff given this new limitation of 50%. Similarly, bonus, there has been no change in the quantum of bonus, but it is good that it is now clarified in the wage code itself. The minimum and maximum are defined and they are still the same as per the previous regulation. An important measure is that gender discrimination is now prohibited. It was earlier also prohibited, but now the wage code has defined it very clearly, and it will be impossible for any employer to discriminate between a male and female employee. So that's going to impact certain organizations which were labor intensive or the work required a male in terms of physical hardship. So given the fact that this gender discrimination is now it's prohibited, it is important for all the companies to relook at their policies accordingly. Next. So I'm going to now move on to another labor code, which is called Code on Occupational Safety, Health and Working Condition. My colleagues have also translated the names of the previous labor laws for ease of reference. I would like to thank my colleague Nita-san for this hard work. Is that Factories Act, mines, and other kind of laborers, there were various provisions under these labor code which related to safety measures, health and working condition. All these 13 codes have now been abolished, and all the measures for health and safety have now been consolidated into Code on Occupational Safety, Health and Working Condition 2020. I would now go on to discuss some of the important amendments. Is that this code is now applicable to a place where any industry, trade, business, manufacturing or occupation is carried in which 10 or more workers are employed. So even where the companies have very few employees, but they are more than 10, they need to take care of this important change, and they need to take measures accordingly. Given the fact that worldwide we have seen the impact of pandemic, including India, government has given itself a power that they can exempt certain organizations from the application of this code on case-to-case basis, maybe to create more economic opportunity or to allow industries to cope up with these extraordinary circumstances. So government can still declare that these codes may not be applicable on certain industry. But important thing is that all the factories where manufacturing process is carried on and they employ more than 20 people, which was earlier 10, where they're using power, and most of the manufacturing these days is done with the aid of power. So it is important for all such factories to take care of these new changes and prepare their HR manuals accordingly. For hazardous activity which can create some danger to the person, such activities are covered irrespective of the number of employees. Earlier it was a limit of 10, so it has now changed. So if an organization has less than 10 but it is engaged in hazardous activities, this code will remain applicable. And of course there are certain maximum limit per day of 8 hours, but working in shift is permissible. And the most important impact of this code is the point number, the last point, which says that prohibition of contract labor in non-core activities. So technically, from now on, an organization cannot employ contract labor in core activities. So there is a bit of typo here. It should be core activities. So the government has defined what is non-core activity. So non-core activities involve activities such as canteen, drivers or gardening or cleaning. So these are non-core activities, and for that companies can deploy contract labor. For manufacturing process or for main activities of the company, employers cannot deploy contract labor directly. Next. The most important of all these regulation, and which is of specific interest to all foreign companies, including Japanese, and since I have been interacting with so many Japanese customers during the pandemic, I noted that there is a clear interest on how to handle industrial disputes, because the circumstances were very tough and they're going to be tougher, in my view, next year also. So the impact of industrial relation is going to be re-evaluated, and it is important to understand how to survive in the coming period. So this code on industrial relation, which has summarized the Trade Union Act, the Industrial Employment Standing Orders, and Industrial Dispute Act, is an important piece which all organizations which are engaged into industrial activity should not miss. So these acts, as some of professionals, including HR department, would understand, pertain to how to manage employee dispute or workman dispute. The code, which is newly formed, is primarily aiming to achieve 3 objectives, which are there on the screen. For ease of reference, I would say the aim is to protect the right of workers, and they can freely form unions. Earlier there was an ambiguity in such matter. Then to minimize friction between employer and employee. This has been a major issue in industrial relation in India. So this code tries to address it, and I would say it's very fair treatment to both employer and employee. The third objective is to provide investigation and settlement of industrial dispute. So with these 3 objectives, I would say the code is new, and it may evolve further based on experiences gained and to address new situations. But I would say that the author of these code has tried to make a very fine balance between rights of workers and right of employers. Next. These are some key features of Industrial Relation Code 2020. They talk about that Again, like OSH code, the code on industrial relation can also be exempted to new industrial undertakings if the government deems fit in certain areas of the country or for certain sectors in order to promote employment or in order to promote growth of the economy. And all industrial establishment with 300 or more workers now must prepare standing orders on certain matters which are contained in the schedule to the code. So these standing orders, which are technically uniform policies pertaining to classification of workers, manners of informing, how to inform the workers, what are the working hours, holidays, leaves, and how they need to conduct themselves for these matters. Termination of employment has now been included in the code itself. So it is now following the procedure in the code, employers can freely terminate the employees. It's a very positive change with a very negative consequence, but it is very important for the investor to know what are the right process of terminating a workforce, and then how to address the grievances or complaints on behalf of the worker. So if there is any complaint, then how to handle. So these 4 standing orders are now mandatory. So recognition of trade union at central and state level is now given in the code itself. And I would say that the rules are very, very transparent as to how the trade unions will work, and no undue advantage can be derived by the trade union over the management. Equally, management cannot actually punish workers for being part of trade union. So I would encourage all the HR department and general affairs department to study carefully if they have trade unions in their organizations, to study this amendment very carefully. Next point is about some two-party bipartite forum for dispute resolution. So now the concept of negotiating union and negotiating council has been introduced in the code. Next. Another key factors are that worker has been defined to include a person in supervisory capacity, which is getting wage up to Indian rupee 18,000 or an amount which can be notified by the government in future. Fixed term employment are now recognized in the code, and fixed term employees are also eligible for certain benefits like gratuity. So if you would recall, those who have experience to work on HR matters in India, a minimum of 5 years of employment with the company was a mandatory condition to pay gratuity. Now, for fixed term employment, this is an exception that period has been reduced to 1 year. So you need to evaluate the fixed term employment in your company and also make provision for gratuity if this issue is applicable to your company. Also, casual leaves have been included in the definition of strike. If more than 50% of the workers go on casual leave suddenly, it would amount to strike and it is illegal. So it is in favor of the employers that casual leaves cannot be taken so casually, and they have to be planned in advance. Also, new features of negotiating union council, I would be talking in subsequent slide. It is now prohibited to to strike, to do strike and do lockouts without giving a minimum notice period of 14 days. And in fact, there is a detailed provision about how you can initiate a strike. I would say it is a very welcome change, and no group of workers or in fact trade union can influence workers to go on strike suddenly. The management will get adequate notice, and there is an adequate mechanism in the code which can prevent strike, as I would explain in the subsequent slides. And also good part is that the industrial tribunals have now been notified to be the having jurisdiction on these labor codes, and going for civil court is now not possible. So once the industrial tribunal decides the matter, unless it is something of a great unprecedented magnitude, the decision would be final by the industrial tribunal. This is an important slide for those companies which have trade unions in their organization, is that you need to now identify if there is a sole negotiating union in your organization, which means a union which comprises of more than 50% of the workers as member. So if you have a sole negotiating union, then it is very easy to negotiate with just that union because it comprises majority of the workers as member. However, if there is no such union in the factory, then there is a concept of negotiating council, which means that those trade unions which have 20% or more members, for example, they can be maximum 5 such unions, 20 which may have 20% or more, which can be part of the negotiating council. If they are less than 20%, then they are not going to be counted for having a seat on the negotiating council. And whatever negotiating council will decide is actually binding on all workers. And all dispute related to discharge, dismissal, retrenchment, or termination of the service of individual workers will be now treated as industrial dispute, and they can be taken up at the industrial tribunal level. And there is a time frame of 45 days about how these disputes will be resolved. And of course, the provision can be explained in much more detail, but because time is of short essence, so this is an important amendment. I will now move on to the next slide. So the next slide really talks about definition of closure, layoff, and retrenchment. Now it is a clear definition as to what will constitute a closure of a factory. Means permanent closing down of place of employment of part of the factory, and what will actually meant by layoff. So layoff means failure or refusal or inability of an employer on account of shortage of power or raw material. So the definition is in front of you. You can actually view it. But all these matters which were not addressed in the previous labor codes have now been addressed adequately in the new code on industrial relation. The 2 pointers which are there on the slide are very important for those organizations which have more than 300 employees or workmen. Please note that earlier, if you had a workforce or more than 100 workers, it was mandatory for the company to take a prior approval from the government before they can actually close the company. However, such condition was actually acting as a restriction or limitation on the companies to grow in size. The government recognized this aspect, and now this limit has been increased to 300. So up to 300 workmen, if you want to actually close down the factory, or you want to lay off or you retrench the workers, there is no need to take any prior permission from the government of India or from the any government authority. And the companies who are in a process of either shutting down their factories or to reduce or to restructure their businesses because of lack of demand or because of economic situation, they can now freely do it without any prior government approval. And the key issue is that one of the major complaints is that the rules in India change very frequently. So now it has been given in the code itself that this limit cannot be reduced less than 300. It can always be increased. However, this act is passed by the Parliament of India, and if the government really want to change the threshold, they can definitely do it. So it's, even though it is mentioned that the government can always increase the threshold, there is a slight possibility if the socialistic mindset is there, and given the economic factor, this issue can also be addressed. I would now move on to slide number 13, which talks about fixed term employment, which is about engagement of workers on the basis of written contract of employment for fixed year. So this issue is not too much there for Japanese companies, because I've always seen that Japanese companies always prepare employment agreement for all of their workmen, but now it is mandatory to have a written contract. So this aspect is now documented in the code. This contract will define his or her hours of working, the wage he's going to get, and other allowances and benefit, which technically cannot be less than of a permanent employee, who's doing the same kind of work or of similar nature. So it's an important thing that no company can actually now exploit a temporary worker or a fixed term employee by paying him less than they pay to a permanent worker. So it's an important change, so do take note of this. And the fixed term employee will now be eligible for all statutory benefits, including gratuity, as I mentioned earlier. And please have a relook on these issues. And it is clearly mentioned that no person can actually go on strike. And if you retrench any workers, there is a provision of reskilling fund, which allows the company to contribute for the reskilling of the workmen who has been retrenched. So all companies will be contributing to such fund, and as and when appropriate, they can utilize this fund. So now this is the fourth important code, which is called Code on Social Security. As you can see that these were important amendments or important laws which have now been subsumed in the Code of Social Security. So total of 9 labor codes. The names are there, as description is also there in Nihongo, have now been made part of Social Security Code. The key features of this code is to consolidate all the laws relating to Social Security in one code. This is going to simplify a lot of administration issue, because now whatever is there in the code and is duly implemented will save the employers from unnecessary questioning from the labor department. So of course, the next few points about the employee provident fund and employees insurance is also provided in the code. It's a very detailed code, but I've tried to capture the key point that the code also defines certain expression as what is the career center, aggregator, gig worker, or platform worker. So these new age terms for the employee are very much applicable on IT companies. So these legislations are equally applicable on manufacturing as well as service companies. So do take care if you are involved in service sector. Good part of these labor codes is that it recognizes electronic submission and digital submission of the returns, application, and certifications. So there is it's a positive feature that you don't have to print too much of documents as you were doing earlier, and you can submit everything online. And when you submit it online, there is an actual audit trail as to when did you submit the application, and there is a turnaround time from the approving authority or the government authority within which they have to reject or accept. So it cannot be pending forever, as was the case earlier. And because of this amendment, companies have to also look at the IT skills of their employees, because it is very important that they be trained on how to operate on the dedicated labor regulation portal, which is Shram Suvidha, and they know all the features. So in my view, it is important for all companies which have workmen or employees to actually encourage and make it mandatory for their employees in the HR department or in general affairs department to actually train themselves, and they should be giving undertaking that they can operate the portal and various returns can be submitted successfully within the due dates. So it's an important change. And government has a power to also implement this social security on self-employed, giving the benefit to self-employed workers or any other class of person. So another slide, I'm on slide number 16. It talks about that the government can actually change the threshold of application of this code, can also exempt any organization. The government has also defined what all categories of workers are required to be registered for social security, and gig workers or platform workers are now eligible for registration and for social security benefits. So please check your HR rules and see if you can, if this is applicable in you, and you have to make necessary changes. Next point is about social security fund. So it's an important change, like for unorganized workers and these, there would be a dedicated social security fund created by the government and also by the state government, and they would be contributing resources for that. Next point is quite administrative, is constitution of various social security organization, and the names are there. I would not repeat that. It's already very much clear. Next point is about for unorganized workers and gig workers, and even for their family members, there would be provision related to employee state insurance, which was not there so far. Provision for maternity benefit to female employees, and certain restriction on what kind of work they can do during pregnancy, or having a crèche in your organization is all there in the code, as were there in the previous code. So nothing dramatic has changed there. Rates for provident fund and other schemes, and for period for which these would apply is also mentioned. So it's kind of routine, but I'm just going to highlight, because this presentation I intend to share it with all of you, so I don't want to miss any key point. So pardon me for if there's any repetition here. Next point, I've already covered the maternity benefit and employee compensation given in the code. All establishment with 20 or more workers, all employers and companies having 20 or more workers, if they have a vacancy, then they would notify any vacancy in the organization to an employment exchange. An important amendment. Please take note of this. And the third point is about an employee or an organized worker or any other person which is there in the organization must be registered as a member of some social security scheme and given benefits of all such scheme, who want to seek any benefit in kind, cash or medical sickness benefit, who want to take away career services, if any organization is giving any career guidance to employees, if any employee want to take benefit of such facility, or they want to receive any medical treatment for themselves or their family members, they must now have Aadhaar card most of you would know that's a unique identification number for all residents in India. So it's even applicable on Japanese who are resident in India. So they now, everyone is now required to have an Aadhaar card who's resident in India, and all employees and workmen. So if you have any foreign worker in your organization, it is now mandatory that that foreign workman or employee should also possess an Aadhaar card, an Aadhaar number. So so technically I have spoken a lot, but if you were to ask me what has really changed, and for certain let's say top management, if they want to know what has changed by these labor code, is that I would say that there are three major points. Is that ease of doing business in India has increased. Means these laws are as latest as 2019 and 2020, very new, and they include all the important terms related to what are the new age concept which should be there in the employee relationship have now been defined. There is a transparency level in monitoring and reporting, because earlier it was not very transparent system of manual filing, or the rules and regulations were not very clear as to how and when you need to file some HR return or some report. It has now been clearly mentioned in the code what you need to do and when you need to do. Electronic and digital is now part of the law earlier, which was not supported. So now going forward, I would say that most of the systems would go paperless, and electronic filing will ensure that there is no corruption also. And then finally, consolidation of laws relating to labor is one major aspect. So those the management people who have spent time in India or in past and who are still uh, engaged on Indian business, they would know that labor code is something, or labor laws was something that they would always request their Indian colleagues to handle. But since now the code has been rewritten and simplified, and once they understand these are the 200 or 500 pages they need to read and understand, there is nothing beyond that. So it increases the understanding and compliance. Second point, I would say that the law now, all the labor code now clearly define what you can do, what employers can do, and what employees can do, and what you cannot do. So there is no gray zone. It has been clearly written that employees cannot go on strike. It has been clearly written that employers cannot uh, discriminate between the workers, or they cannot make any condition which is totally unfair to the worker. So do's and don'ts have been clearly defined in the code itself, and this is a very important change, I would say. Personally, as a professional, as a lawyer, as a chartered accountant, I also have struggled because there were too many laws, state laws and central laws. It was very difficult for me also to understand and explain it to my client. Now it becomes simple for everyone. Then another major point which I always get queries on is dispute resolution. So these codes will now minimize friction between employer employees. Works committee is now applicable, and there's a concept of works committee. Even it sets fair rules for negotiation, and grievance redressal committees there should be created by all the companies to take care of workers' concerns. So these are important changes. What uh, what has to be taken as an immediate attention by all companies is that they now need to familiarize themselves with the concept of inspector cum facilitator. So those of you who are related with Indian business, you would know that labor inspector is a very dangerous term. And now this term, there is a reform to the labor inspector role also, that his role is actually also to guide the company. But trust me, it is equally important for all the corporates and their HR and general affairs department to understand what are the powers and duties of these ICF inspector cum facilitators, so that they would be able to deal with them effectively. ICF have too much power. I would say they have become more powerful under the new labor code, but they have now also been given a clear do's and don'ts, what they can do, what they cannot do, including that whatever information that you would submit with the government department on their portal will now be treated as very secret and confidential. But then we all know that we cannot divulge more than necessary information to anyone. So now all the companies need to relook at the confidentiality policies also, and what information they can share for these compliances and whatnot. Mostly there's usually for labor compliances, there's not such, you don't share so much of sensitive information, but this is an important change. Constitution of various committees, works committee is now mandatory for 100 or more workers if there are in your factory or company. Grievance redressal committee is mandatory for 20 or more. So I would believe that all Japanese companies operating in India or are going to start working in India are going to take note of this and see what is applicable to them. And the important change is that now you need to have women representation equally in proportion to the total workers in the factory on these committees. So take note of this. The next point is dispute resolution. I've already covered, but this is the order, I would say, some of the key points that create a grievance redressal committee in your company. Understand the conciliation office, which is a authority in the code to resolve dispute externally outside the company. Then if the dispute cannot be resolved, please understand that these dispute will be dealt with at industrial tribunal, so which is a final forum in my view. And then what you need to do is to have a strategy for resolution of dispute, redrafted and rediscussed amongst the core team managing HR issues in the company. And also it is now given in the code that all the disputes can now be handled through arbitration. So another important point, so if you need to amend your HR manuals to put in arbitration clause, please do take note of this. Next point is about slide number 21 is about please study the provision of strike off and lockout, how they impact you. Do study special retrenchment provision and layoff and closure, specifically for the companies which are trying to restructure in near future. This is going to guide you how you can actually implement those changes which are important for future. The third point is re-employment of retrenched workers. So if you're going to retrench workers and then you're going to hire new workers, so you need to pay attention to section 71 and 72 of Industrial Dispute Code, which talks about re-employment of retrenched workers. Of course, if someone has been fired for disciplinary issue, he would not be eligible, but do take care of this aspect as well. Prior notice to state government for closure of factory is now mandatory. You cannot close the factory without informing the government, state government, irrespective. And then please do understand the jurisdiction of various forums, which labor code will have jurisdiction on, because if you have multiple factories in India, then you need to prepare yourself accordingly. There are severe penalties in the labor codes. The imprisonment threat has now been diluted, and you can actually pay fine for certain offenses instead of going for imprisonment. So the code has become more sensitive on these aspects, because earlier these kind of threats were very disturbing to our clients because there was fear to go to jail. Now these provisions have been diluted, and you can actually pay fine in lieu of going to prison. Sorry, so these important. Please do take care of these issues. Then the second point is about contract labor. Is that prohibition of contract labor for core activities I have mentioned. you cannot hire contract labor in core activity. So some of the companies which are actually operating through contract labor directly, they now need to understand. Then various conditionalities for engaging contract worker are there. Unfair labor practices have been defined, and impact on employer and employee has been defined. I will share this slide, but since the time is running out, I would just quickly say that registration of trade unions, if 10% or 100 minimum workers are required to register, mandatory to be able to register trade union, but you need 7 members to register a trade union. Then members can be temporary or permanent also. So do hire workers very carefully. If you hire temporary workers, they can also create trade unions. So please be very careful on these aspects. Do make rules for negotiating union and negotiating council. It's very important. Do create standing orders, point number 2, for your organization if they are applicable to you, which is there. I've tried to write it in simple language. And do take care of all the grievance redressal committee dispute resolution in your company. So these are some important changes which I think are applicable. And now if I would end my presentation here, and I thank you for your patience while listening to me.
Thank you very much, Himanshu-san. 時間が少しばかりありますので、質問をちょっと拾ってみたいと思います。先ほどあった、契約労働者に関する問題ですけども、雇用が禁止されているということについて、もう一度説明をお願いしますということなので、Himanshuさん。Himanshuさん、can you hear me? Himanshuさん。
Yes, Kono-san.
Okay. Yes. So one question I just picked up, one or two, because we have limited time. You explained about the contracted labor on the last part of the page. Is it now prohibited to hire contracted labor for core activities? What can, Japanese companies do or must take the action about that?
Okay, thank you, Kono-san. That's a very good question. I have been responding to this kind of query from many companies, is that the contract labor is now prohibited to be directly engaged by the company. However, companies can engage contract workers through contractors. So it's very much there, but contractors have to ensure that they comply with all the labor code provision and rules and regulation. So there's going to be some change in the way the companies have been doing business. That is, now they need to disengage with the contract workers, and if they need them, they need to hire them through contractors.
Okay, I understand. Then one more question. Now, under the new labor law, what are the critical, excuse me, first in Japanese. この新労働法の下で日本の企業が、気をつけなければいけない点、あるいは取らなければいけないアクションというのはどういうことでしょうか。What is the critical points or that all Japanese companies has to take care of or do some activities to take under this new labor law? What are they? Can you itemize?
Okay, thank you, Kono-san. Again, a good question, but I would like to request our audience members to understand that I'm going to share the presentation with them. So in the presentation, I had 4 slides, which talks about what are the immediate steps, and there are about 15 such issues which are listed, and all the companies, whether they have workforce small or large, these issues are all applicable on them. So labor codes are mandatory to all. Of course, there are certain threshold, but they need to understand and make changes to their existing HR policies, and also some industrial dispute committee, if they have, how to manage workers, how to address the complaints and grievances. So these points I have highlighted in the presentation. In the last 4 slides, I would request once I email my presentation to all the attendees, please do go through them. And if you have any queries, please do share your queries with us. I'll be very happy to respond to them.
Thank you very much, Himanshuさん。どうもありがとうございました。時間も参りましたので、今日のセッションは終了をしたいと思いますが、もう一度その前にお願いをいたします。皆様のチャットボックスの中に、横浜インドセンターさんの、アンケートに関する URL が出ていると思います。ご退席される前に、ぜひアンケートの回答にご協力をお願いいたします。それでは、本日短い時間でしたけども、ご参加いただきましてありがとうございました。質問に関してはどうぞ遠慮なくメールでお寄せいただきたいと思います。それではこれにて今日のセミナーを終了したいと思います。ありがとうございました。Thank you very much, Himanshu-san.
Thank you, Kono-san. Thank you, everyone. Arigato gozaimasu.